Swayam Prabha. Digital India. Educated India. Swayam Prabha. Digital India. Educated India.
Welcome to the course of Law of Torts, Consumer Protection and Motor Vehicles. Today we are in the 7th lecture and we will discuss we will continue to discuss our topic on liability. Now in the previous two lecture I have discussed about incurring individual liability. So I spoke about fault liability and the no fault liability. Now these are principally where an individual wrongdoer is involved, but there can be more than one wrongdoer. Now they can be severally responsible for the transaction. Sometime it may happen that one person has actually committed the wrong, but the other person can be also included into it because of certain existing relation or certain other ways by which that second person accepts the liability. Law imposes, of course, the relation based sometimes this joint liability. This is called joint liability, and we will discuss the concept of joint liability in torts today, and it is called as vicarious liability. It's a form of liability which is usually when relationship exists. So we will discuss that today. That is our topic. But because the vicarious liability concept is a quite and it covers a lot of things, so maybe it is possible that we will spill over this lecture to the next lecture and we will complete it in the or conclude the entire discussion of vicarious liability, part of it in the next lecture. So in this lecture we will cover these aspects of vicarious liability, which is nature and scope, doctrine of respondent superior. So vicarious liability, as I said, is imposed on the basis of relationship. So when a servant commits a tort, can the master be held liable for that tort for some reason? For example, I have a car and my car is driven by a driver whom I have employed, and I have given him clear direction that this is how he has to drive, this is what are the areas or the destinations he has to cover, this is his routine. Now in course of that employment that I have provided him, if he commits some accident and if it is not purely outside the scope of his employment, that is, I have told him to never drive beyond speed limit and he was driving at a much higher speed, except those kind of scenarios, even those kind of scenarios may sometime qualify, I will be also jointly held liable with my driver under this concept of vicarious liability because of this principle of the doctrine of respondent superior. It is a form of a doctrine that is applied to determine when this kind of secondary liability on me will apply. And then we will discuss about the master servant. So the classic area where this liability is used is master servant, and in that we will also see a test which determines that whether he is my servant or whether he has done that in course of my employment is the real connection test. The other some aspects of this will be discussed in the next lecture. So we will begin with the vicarious liability and its nature and scope. But before going to vicarious liability, there are three ways. As I said, there are ways by which this responsibility or liability can be assumed or can be presumed. Assumed is sometimes when a person himself assumes that I am liable for the wrong of that person, and sometimes law presumes. So it can be assumed or presumed. So, a person may be liable in respect of wrongful acts or omission of other in three ways. First, as having ratified or authorized the particular act. So, when I have ratified or authorized that particular act to do, I told my servant, go and throw some garbage in the garden of my neighbor, and he does it. So, therefore, I have a responsibility. So, I have authorized that work or I have ratified, knowing that very well it is a wrong act, it is a wrongful act, it injures my neighbor. When I have authorized it, sometime I ratify. So, I can assume that okay, my servant has committed this wrong, this was in course of my duty, and I will assume because he does not have the means to recover, to pay the compensation, so I will assume the responsibility. So, ratification or authorization, that is one. Second is a standing towards other person in a relation entailing responsibility for the wrong done by that person, which is vicarious liability. So, vicarious liability is presumed by law in certain particular types of relationships, and under those relationships, the wrong committed by another person who is the actual wrongdoer, the liability is also vested, or liability in the law is also fall upon the other person who stands in such that kind of a relation. And the third is having abetted the tortious act. So, abatement. So, I have instigated or I have made someone to commit a tortious wrong. So, abatement. Now, ratification, authorization or abatement is not very much largely discussed or largely not a important aspect of law of torts. So, we will move to the important aspect in the this joint liability is vicarious liability. However, liability by ratification, there are certain conditions. So, when this liability by ratification can happen, there are certain conditions. This is not vicarious liability, this is the first form, which is liability by ratification. Certain conditions may happen. What are these? When an act done by another person, not assuming to act for himself, when an act done by another person not assuming to act for himself, but for such other person, though without any precedent authority whatever, becomes the act of the principal if subsequently ratified by him. So, my neighbor and I have a long time existing feud, and it is well known to everybody. So, my servant, who is a loyal person to me, day before saw I was very badly insulted by my neighbor. So, what he does is that next day he goes and throws some garbage in the garden of the neighbor. Now, of course, it is an act which he has done, and maybe in the beginning I had not given him authority, or if I am authorized then it will come under abatement. But maybe I have not, but subsequently I ratify, yeah, okay, I will take the responsibility. So, subsequently I ratify. If at the very outset I would have told him, you do it, that may come under instigation or abatement. I instigated him to do it, okay, on my behalf, or he himself did it but under my instigation, then it comes under abatement. But when it is subsequently ratified by me, so the language is very clear, but for such other person, though without any precedent authority whatever, becomes an act of the principal if subsequently ratified by him. So, subsequently I ratify. Subsequently I do not scold him. I said, "Bahut badhiya, you did excellent, I will give you special reward for this." That is the ratification. But this operates under certain conditions. So, what are the conditions? The conditions are three and mentioned here. First, it must be shown that the person ratifying the act ratified it with full knowledge of being tortious. So, two very important aspects. The person who is ratifying it must have the full knowledge that the act is a tortious act. So, throwing garbage in the garden of my neighbor is a tortious act, and I have full knowledge of this, yet I ratify. Then I am falling under the condition of ratifying the act. Second, only such act binds the principal by subsequent ratification as were done at the time on the principal's behalf, or when he has done it on my behalf. So, for example, he was on my behalf, the servant went and punctured the tire of my neighbor's car. Then it is done on behalf of me because I expressed that if his car's tire is punctured, he will not be able to go to the office. So, therefore, this is where the act binds the principal by subsequent ratification as were done by the principal on behalf of the principal. And third is an act which is illegal or void is incapable of ratification. If the act is illegal or void, then the act is incapable of ratification. So, if there are certain acts which are per se illegal or void, and it is done, then it cannot be ratified. Now, coming to the question of liability by relation, which is our main concept of today's discussion, which is vicarious liability. The concept here is that master or certain other in relation, the principal becomes liable for the act of his servant. It can be agent, it can be employee, it can be anyone, but the principal may become liable because they fall within that type of a relation. Okay? Now, the question is why this kind of a liability was at all derived in law. So, why should the master be held liable for the torts committed by his servant? That is the first question. Of course, that comes to anyone our mind that why this kind of a joint liability. I was not in the picture, I may not have authorized him totally, I may not have done anything, but still because of his negligence now I will be held liable. Now, why? Now, there are historically three principal reasons. The first is the historic reason, which is the notion that his servant personality was merged into the family of the head or master. So, what law historically had seen is that the servant and the masters are not separate. The servant independently has no legal personality when he is doing any act in capacity of being a servant. Of course, when he is doing an act in capacity of an individual being, and when that individual being capacity and servant capacity, that is what we will discuss in course of this lecture. But when he is doing something in course of his independent being, he will not come under the relation. He has his personality. But when he is a servant and he is doing an act on behalf of capacity of a servant, then historically law has not given any personality to the servant. The personality of the servant is merged into the head of the family, which is the master. So, whoever is the head of the family, the master, the servant's personality is merged into him. So, therefore, that is why the legal personality is in the master. The second reason is a public policy reason. The public policy reason is that there ought to be remedy against someone who can pay the damages, and the master is expected to be in a better position of paying the damages than the servant. Now, I have employed two servants to do some construction work or some painting work on the outer wall of my building, and just beside that outer wall there is a pathway, and it is quite a busy pathway, a lot of people are travelling. Now, it is the duty of the servants when they are undertaking that construction work or the painting work that they should properly guard so that no waste material or no construction material or paint falls on any way who is passing by on that pathway. But they do not do that. They are negligent. It is not that I have told them not to do it. Maybe I have instructed them also, or may not have, but they do not desire or they do not think it is necessary. So, what they do is that they start the work directly, and in the process some concrete piles fall on the head of a person was walking on that pathway and got severely injured. Now, this is a negligent act causing injury, and hence the servant should be held liable. But the question is the servant is in a position to pay compensation. Now, individually the servant may not be in a position to pay the compensation. Just because the servant is not in a position to pay the compensation, is it fair in law to excuse? Because the wrong has been done, the injury has been caused, the loss has been suffered. But just because that person is not in a position to pay, and which is usually with servants, will it be appropriate in law to excuse? Of course, the answer is no. And hence, for public policy reason, this particular principle has developed that the master is considered to be in a better position to pay. And because the master is in the better position to pay, the master should pay in this case, although the wrong has been committed by the servant. And this has led to this doctrine, which is respondent superior, or qui facit per alium facit per se. In Latin, the doctrine is qui facit per alium facit per se, qui facit per alium facit per se, which in English we call respondent superior. What this doctrine means? This doctrine means that every act which is done by a servant in course of his duty is regarded as done by his master order, and consequently it is the same as it were the master's own act according to the maxim. So, every act that has been done by a servant in course of serving his duties of the master, it is presumed that it is done by the order of the master, and therefore it is the master's own act, and hence if there is any loss or injury caused because of the act, the master has to pay the compensation, or the master will be equally liable with the servant. Now, the master is mainly the principal liable person in this case. What is the condition? The condition is that servant has committed the act in course of his duty. This is very important, course of duty. We will see how this has repercussions in law in the subsequent discussions in course of this lecture, but at this outset it is important to note servant has committed this in course of his duty in regard as done by master's order. So, master's order is there, and it is therefore according to law it is considered master's own act. It is part and parcel of master's own act. Now, this concept of respondent superior, or this maxim of qui facit per alium facit per se, was discussed and evolved in these two cases. The first case is Stanley Iron Chemical versus Jones 1956 and Imperial Chemical Industry versus Shotwell in 1964. Both decisions were by House of Lords, and House of Lords, explaining the object or the reason behind this, held that it is a rule of law, very important, it is a rule of law that the employer, though guilty of no fault himself, is liable for the damage done by the fault of the or negligence of his servant acting in course of his employment. So, the employer may not be guilty of any fault directly, he may not be guilty of any fault, but the fault has been caused due to the negligence of his servant, but he will be held liable for damages for that, if the act is conducted in the course of employment. This is very important, in course of employment. And in Imperial Chemical, the House of Lords stated again that servants taught that the master is vicariously liable. So, for the servants taught which is conducted in course of employment, the master is held vicariously liable, but the master will be primarily liable if there is non-delegable duty. So, the liability will be when there is a non-deligible duty, non-deligible duty laid on him by common law, non-deligible duty laid common law or statute, or when he is negligent in making selection of his servant. So, when there is a non-deligible duty, so sometime law imposes a non-deligible duty, or a statute has imposed some duty, or he has made a negligent in making selection of his servant. Now, for example, he wants to employ some people for the purpose of painting work, and he employs some people who are primarily masons, because they come and say, we can do this work and at a lower cost. So, to save the cost, he employs these people, and these people in course of doing the work, because of their negligence, lack of experience, lack of technical knowledge, commit some tort. Then in that case, the master will be held liable. In other cases, the master may not be liable. So, the master is primarily liable. So, in this 64 case, in 56 case it says course of employment, but in 64 case the court says that if there is a non-deligible duty A, B, by common law this non-deligible duty is established, or by statute law, or he makes a negligence in selecting the servant. These are some of the conditions when he will be held liable primarily. In other situations he will not be held liable. Now, the important test is that sometime I may directly employ my servants and directly pay, and they are working under my direct control. On the other hand, I may employ an independent contractor. I may tell him that this is the work that is required to be done, but how it is to be done, what are the requirements, when it will not be a negligent work, when it will not be something which can cause damage to someone, it will be a decision of the independent contractor. So, these two categories of persons can be employed. Now, will the liability of vicarious nature for the master or the employer in both these scenarios will be same? So, that is an important question to be determined. So, the question is that servant and independent contractor are both employed to do some work for the employer, but is there a difference in the legal relationship which employer has with each of them? Now, if the liability regime has to differ, then there has to be a difference in relationship. If there is no difference in relationship, there will be no difference in the liability regime. The liability regime will apply in the same manner. But if there is a difference in the relationship between them, then there will be a difference in the manner in which each of them are in relation with the employer or the master. Now, if we look at the distinction, the first and the foremost very important aspect is a servant is engaged under a contract of service. Contract of service. I have contracted him to work under me, contract of service. And the independent contractor is engaged under a contract for service. So, what is the legal implication of just removal or change in this one word for? Here it is contract of and here it is contract for. So, what is this distinction that creates between the two phrases when of is replaced by for? There is a world of difference. Contract of service means somebody who is under my direct control. I have employed him, my maid servant. Contract for service is where I have contracted for getting some service. Now, I have paid a money to a taxi driver to take me from Calcutta, from my house to the Howrah station in Kolkata. and I have a car and I have a employed driver and I have asked him to take me from my house to Kolkata, Howrah station. Now they are not same. When it is a driver who is driving my vehicle at my cost, petrol cost, my direction, my control, he is in contract of service. He is a direct employee of me. Whereas in contract for service, I am paying only for the service that I am hiring or availing. And the person who is providing the service, he will do it independently. His contractual obligation with me is just to ensure that the service which he has to provide is completed without any fault or imperfection. So, he has to take me to Howrah station at a particular point of time, he has to take me. Now, how he will drive, what speed he will drive, what route he will follow, that is not my business. But when it comes to a driver, all these are my business. I will tell him take this route. I will tell him this time we have to reach, therefore this much speed you apply. If he is over speeding, I will say don't apply. If a taxi driver overspeeds and causes an accident, I will say I didn't ask him. But a driver, if he overspeeds and causes an accident, I cannot say, because I am the owner of the vehicle and I am sitting behind him. So, contract of and contract for service therefore has this very important distinctive feature. Based on that, the subsequent distinctions are drawn. So, second distinction is liability of the employer for wrongs committed by the servant is more onerous. Of course, because he is in my control. I am giving him direction. I am telling him this route to follow. I am telling him within this speed limit to drive or overspeed. So, therefore, my liability with the servant is more onerous, with the driver is more onerous, whereas liability of the employer for the wrongs committed by independent contractor is less onerous, because he is supposed to do it at his own. Now, I employ as part of my university some direct employees who are supposed to do cleaning work. Now, after cleaning a place which is still wet, because they have cleaned with water and soap and all this, still wet, they are supposed to put a caution that there is a wet floor, but they do not do it, and somebody walking there slips and falls and gets injured. Now, of course, the fault is of the employees, but I will also be liable because they are my direct employee and I have tell them not to do it, but they negligently do it, but my responsibility still is there. But if it is a housekeeping company which I have hired for the purpose of cleaning work and it is done by some employee of that housekeeping company, I am not liable. I told that I have given them the contract, I have told them the house needs to be cleaned. Now, how they are doing it, I am not supervising it, they are not in my control, I am not supposed to tell them. So, therefore, my liability becomes less onerous, whereas in the first case my liability is more onerous. And the third one is that traditionally it was a position that in case of servant, the employer, in addition to directing what work the servant is to do, can also give direction to control the manner of doing the work. So, traditionally when it is a servant, as an employer I had two powers, one directing what work and direction to the control the manner of doing the work. So, as to my driver, I can say I want to go to Howrah station, and then I can also, and I am supposed to direct him what speed, what route, how he should drive. But with the independent contractor, the employer can only direct what work, but how to be done and the manner of doing is not in the control of the employer or the principal. It is for the independent contractor to do it. So, therefore, because of these pre-existing distinctions between the servant and the independent contractor, the liability regime also differs. So, the traditional approach to determine when a question of wrong of a third person of this nature has arisen, say the example that I gave, that I had employed somebody and that person failed to perform it in the proper manner. There was a negligence and that has caused loss or injury to another person. Now, that person does not know what relationship that that particular person who committed the negligence on the ground has with me. Now, he will always file a case against both. Now, the onus is on me to show that whether he is my servant or he is my independent contractor, or whether he is an independent contractor. If he is a servant, then I have a greater liability and very limited ground I will be exempted. But if he is an independent contractor, my liability is less and there are more bigger grounds. But how do you determine when there are very not clear distinguishing features? So, the courts therefore developed a particular type of test which is called the control test, which is a traditional approach. And in the control test, when they were faced with this question that whether this person is a servant or an independent contractor, they used to employ the control test and see that whether it is a contract of service or it is a contract for service. Now, with reference to contract of service, these following indicators would be fulfilled. And if it is a contract of service, then I have the liability vicariously because he is my servant. But if this is not fulfilled, then it will be contract for service and then I have lesser liability or in most cases no liability. So, in Short J and W Henderson case, Short versus J and W Henderson case in 1946, the court employed the control test and stated that this 4 criterion is required to be fulfilled by using the control test with reference to contract of service. What are these? First, the master has the power to select his servant. So, it is completely my discretion whom I want to employ. Then I am going to pay him a wage or a remuneration. So, he will be a employee under my role and I will pay him a wage or remuneration. I have a right to control the method of doing the work and I also have a right to suspend or dismiss him at my will. Of course, there will be contractual terms. Based on the contractual term, I have the control to determine when I want to suspend or dismiss. There is no other person. Now, when it comes to a taxi driver and my driver, the example. Now, if we employ the contract control test, it is very clear the driver will fall within this category, but the taxi driver will not. Because who will drive the taxi? It is not my power to select. I can just call a taxi. Now, whether it will send a male taxi driver, a female taxi driver, a taxi driver who is a very polite gentleman or who is a rough rude fellow, a taxi driver who usually drives in a smooth manner or a taxi driver who is very fast driver, I have no such control. Second, taxi driver in lieu of his service I pay him fare, but driver in lieu of his service I pay him wage or remuneration. Taxi driver I have no control other than saying I want to go to Howrah station. But with my servant, I have full control as to tell him which route to follow, what speed to control, and lastly, I have no right of suspension or dismissal of the taxi driver. So, therefore, by using this test, it is very clear from our example that the taxi driver will not qualify at any point of time within the criteria of a servant, whereas the driver will always qualify within the criteria of a servant. But the problem with the control test is that the control test worked well when the relationship or the nature of employments were not so modern or not so complicated. But now the relationships of employment and contracts of employment or services are very, very complicated. So, simply by approaching this control test and these 4 criteria, we may not have desired result in most of the cases. So, therefore, where control test fails to give a desired result, then a more modern approach can be used. And what is this? And or where control test fails, before what is the modern approach or alternative approach? Let us see where the control test can fail with reference to the contemporary complexities of employment nature or relationship nature of an employee, master servant, etc. The first is the control test breakdown when applied to skilled and particularly professional work, and therefore it cannot be relied as an exclusive test. Now with hospital and doctor. Now is the doctor a servant of the hospital or he is a independent contractor? The control test may not give a desired answer looking at the nature of the particular contract, because the doctor may not take wage but may take percentage of his consultancy fee. The doctor may not at all be totally employed, but he has in course of the day has long engagement in the hospital, and what treatment cannot be controlled by the hospital, but his other governing service natures are controlled by the hospital. Second, the existence of the right in master to supervise the control or execution of the work done by the servant is a prima facie test of the control test, which is not possible, as I said, in the example of the doctor and the hospital or several other things of modern nature. Nature of control may vary between business to business and by its nature incapable of being precise definition. So it may vary between business to business quite widely, and it may not be incapable to have a precise definition, and in some cases, although all these criterion may be fulfilled, but it will still appear that he is not the servant, and in some cases it will not fulfill, it will still appear it is a servant. There are many contracts in which master could not control the manner in which the work was done, and this was discussed by the Supreme Court in this case of Dhana Gandhra chemical work versus State of Saurashtra, and therefore Supreme Court held that control test cannot be with reference to the modern employment or modern contractual relations between employer employee or master servant cannot be the sole determining test because of the limitations. So an alternative approach has emerged, and this alternative approach has been emerged in these two cases. The first one is a more complex condition. First one is called Montreal versus Montreal Locomotive, where the court says that in more complex conditions of modern industry, more complicated tests have often to be applied. According to him, it would be more appropriate to apply complex tests involving control, ownership of tools, chance of profit and risk of loss. So usually a master servant relationship, these factors will not be there: ownership of tools, chance of profit, risk of loss. Master will suffer, servant will not have anything to do with all this, right. So more deeper understanding of the complex scenarios are supposed to be taken in context, right. There are several such occupations today where all these things are very, very important. Secondly, in Li Ting Sang versus Chuang Chi Kwang case, the Privy Council held a casual worker on a building site to be an employee of subcontractor for whom he was working at the time. He suffered an accident, although it was found that he worked from time to time for other contractors also. In holding so, the Privy Council approved the test laid down by Koch J, which is follows: control will no doubt always have to be considered. Koch J said that control has to be considered. It is not that the control factor is completely eliminated, control will be there, but it cannot be regarded as sole determining factor. So which may be important are such factors as whether the man was performing the service provides on his own equipment or on the equipment that was provided by the employee. Whether he hires his own helpers or the employee provides him the helpers. What degree of financial risk he takes? What degree of financial risk he takes? What degree of responsibility for investment and management he has? Whether and how far he has opportunity of profiting sound management in the performance of the task. So, control is of course one, but say I have employed one person who is a part-time employee. Now, he needs some helpers. Now, I have given him full right to employ helpers according to his choice. And I have said that I will only pay you. I am not paying to anyone. I am giving you this job to be done within this period of time, for which whatever you want to do, you do. You employ 100, you employ 40, you employ 10, it is yours. What tools needs to be used, it is yours. What management policies you want to apply, it is yours. Where you wish to do, it is yours. How much profit you make from here, it is your decision. I will only pay you this. Now, is he a servant? Of course, he is not. But on the contrary, if I say the same task, you do it, my computer, these are my staffs who will help you, this is the timing, and this is what you are going to get on a wage or a remuneration basis. And after this, you will continue to do this work on a continuous basis. Now, it is not a small time employment. So, therefore, he will come under the concept of servant. So, the modern engagements quite vary. Today, for example, in the software industry, there are employees of X company working with Y company to provide service to Z company. Now, if there is a negligence committed which leads to Z and his clients, which are H, I, J. Now, the employee may be liable, but who will be liable for vicarious responsibility of the employee? It will be X, Y or Z. Because technically speaking, he is originally the employee of X, because X has hired him. Now, X then give him to Y, but at that point of time, his control of work is in the hand of Y. And Y pays to X and he gets salary from X, however. And then what happens is that he is doing the work on control of Y for Z and his clients. So, in this complex scenario, just control may not be the only possible way to determine. So, that is the reason why law has determined that more complicated test, and the alternative test that has evolved is where factors like control, ownership, chance of profit, risk of loss has to be considered, and these two cases are where alternative tests have been evolved. Now, coming to the question of hospital authority in light of this. Now, are hospital authorities now liable for the negligence of the professional staff? A doctor committing medical negligence, a paramedical committing negligence, a fourth class staff committing some negligence, for example, leaves a wet floor in which a patient who is already having some earlier ailments slips further and that aggravates and he goes into a serious stage, which was probably would not have happened if this injury would not have been sustained. Now, will the hospital authority be held liable, and in whose case? The ward boy who is a direct employee, and if the ward boy is not his direct employee, the ward boy is supplied by a housekeeping service which he has hired. Or in case of a doctor who is coming as consultant, or a doctor who is a full-time residential practice doctor associated with the hospital, or a doctor who takes salary, instead of salary takes percentage of all the work he does. He is a full-time employee, but he does not take any salary. So, he conducts 30 operations and from the operation he charges an amount and does 300 consultancies in a month, and for that he will charge. So, 10 consultancy and 1 operation is his per day routine, and whatever he gets is the earning of the hospital from the patients. Or for that he will get 60% of that. That is the agreement. Now, he is an employee, he is a staff and he does not do work anywhere else. So, all the distinctions earlier drawn between professional duties and ministerial administrative duties have been disapproved. And in the case of Santa Garg versus Director of National Heart Institute AIR 2004, Supreme Court held that a petition for compensation against a hospital could not be dismissed by the consumer forum on this ground that the doctors responsible for negligence were not joined. It is approved the proposition developed in CCD's case decided by the Court of Appeals of UK Wales that hospital authority is liable for negligence of professional men employed by the authority under contract for service as well as under contract of service. So, the difference between contract of service and contract for service which we discussed earlier has now blurred. With hospital management, it has no impact. The authority owes a duty to give proper treatment, medical, surgical, nursing and like. Though he may delegate the performance of the duty to those who are not his servant, it remains liable if the duty be improperly or inadequately performed by its delegatees. So, in the CCD hospital's case, it is said that the hospital, two important findings. One, the traditional distinction between contract of service and contract for service with hospital authorities is blurred. It cannot exist because of the nature of the complexity of the different arrangements by which hospital and these employees are working. And second, the hospital shall remain for all the services that it is supposed to provide for the patient and duty bound if it is improperly or inadequately performed by its delegatees. So, two very important findings. So, with the hospitals now, this contract of and contract of for service does not exist. Now, lending servants. This is very common now. IIT Kanpur for example, where I am recording this lecture, for majority of his housekeeping, security or other works are not employing any employees by it. What it is doing is it is hiring service from other agencies who are specialized in this. So, these servants are now lent to IIT Kanpur. Now, if they do negligently some work and commit some tort, who will be liable? IIT Kanpur will be liable or the agency will be liable? So, the question is, when a general employer lends his servant with or without machine under a contract or otherwise to another person, whether there is any change in the master for the period of the servant doing the work for that another person. So, there are different kinds of jobs. Now, some jobs require some kind of support of machines. So, the master may master may provide the servant as well as the machine. For example, a crane operator. So, the master will send the operator and the crane. On the other hand, a security guard or a housekeeping staff, the master has sent the staff. But what happens if this temporary lending has happened, whether there is a change in the master, because they are in the role of the original employer or the company who is hiring them, but they are right now working in IIT Kanpur under the control of the IIT Kanpur. Does this change the relationship and IIT Kanpur becomes the master or the original employer continues to remain the master? So, in the case of Mercy Dock Server versus Coggins in 1946, this question came before the court. And the court said there is a strong presumption that the general employer continues to be the master. So, court says that the first is the presumption is the general employer of that worker or the employee remains the master. How the burden is now on the general employer to prove that there is a transfer of service. The burden is on me that I have transferred him to the IIT Kanpur for this period of time. The presumption in law is that he is my servant, but I can discharge this burden. This is not a disprovable presumption. So, the presumption is there, but that presumption is not proved presumption. This presumption can be disproved. And how you disprove? First, you show that there is a transfer of service, that is condition 1. So, the presumption is that he is my service, but I can disprove this presumption by proving A, that there is a transfer of service, B, the entire absolute control of the servant was transferred to the hirer. So, the entire absolute control was transferred to the hirer. Second, the servant had expressly or impliedly consented to the transfer. Third, the term in the contract between the general employer and the hirer stipulating as to who shall be the master. So, where there is a clear term in the contract, then it will be governed by the contract. But if there is no express term, then these two conditions will be there. Two conditions will be examined. One, that there is an absolute control over the servant and the servant has expressly or impliedly agreed to this control. In the second case, in Savoy versus Holland Hannen, although this was a case where machine was late with the man, the same principle has been followed when man alone is sent done without done for another work. So, in the second case, a machine was also a crane operator and due to his negligence, but that did not change the finding of the application of the rule that was developed in Mercy Dock, because the machine was also sent, because ultimately if the two things are proved, so the burden is discharged. One, either it is expressly mentioned in the contract that who is the master, or when that express language is not there, then who has absolute control and whether the servant is aware that there is an absolute control and he has consented to that. Now, where you are not hiring your employee but some chattel. So, although there is no relation of master or servant when owner permits his vehicle to be driven by another, but in some cases this may become important. Vehicle belongs to me, but it is driven by a person whom I have given the vehicle on hire, his employee. There is a accident. Now, who is responsible? So, in Rambaran versus Gurcharan, in that case, son driving the car for his own purpose without the knowledge of his father, but under implied general permission, it was held that the father who has the owner was not liable. So, son drives, but there is an implied general permission and the father is the owner, but the father is not liable though there is an implied general permission. Because why? The Privy Council holds in this case that a motor vehicle raises an inference that the person driving at the time of the accident was the agent or servant of the owner, but the presumption can be rebutted. As I said, it is a rebuttable presumption by showing that the driver had the general permission of the owner to use the vehicle for his own purposes. There is a general permission, it is a rebuttable presumption. Now, moving to the extent of master servant liability, I would like to say that the law is settled that the master is vicariously liable for the acts which the servant is acting in course of his employment. But when an act is not in course of his employment, he is not liable. Secondly, is also an important question: what is the course of employment? That we will discuss in our second lecture. Next lecture. So, the next lecture will continue that when the master, to what extent the master is liable for the servant, and what is this course of employment, which is have been held earlier also I have pointed out such an important factor. So, the doctrine of course of employment. Okay. So, I'm looking forward that all of you should join me in the next lecture. Presently, thank you very much.